Good evening. My name is David Hiltzman, and today I'm going to be going over some slides over data ownership and legal issues that are surround them for CS 4883. This is going to be for social issues in computing. We're going to get started. So I want to talk a little bit about, we're going to do a bit of an introduction. We're going to talk about data protection in France. Then I want to talk about how it's different than the data, how we handle our data in the United States. And that's going to kind of lead us into more of a more in-depth conversation about the protection of privacy in Germany. And that's with labor law and honestly just about anything when it comes to data privacy and things like that in Germany. And then we're going to talk about why this is such a problem for the United States companies who try to move across the pond and try to move into a different environment. And then we're finally going to kind of talk about it's called the General Data Protection Regulations. This was some laws that were passed in 2020, and we're going to talk about that, and then we'll briefly go over some recommendations, and that will do it. So let's get started. So I want to go over just a brief overview about how the protection of privacy and data ownership. Data ownership is referring to the possession and responsibility of information. This really varies widely between experts and different people who have a say in this. In security and data governance, they believe that it's up to three subsets: it's ownership, stewardship, and custodianship. The thing about data is that it's not physical, and so you have to figure out who owns it. Is it the person who made it? Is it, like, for example, if it's my information, in a database, do I own that? Do I get to have a say with what's used in that? Who takes care of it with the stewardship, and who maintains it? Who follows it? Who makes sure that everything's going the way it's supposed to be? So at the core, it is driven by the value of that each interested party. So for the example of my information in a database, I only have a little bit of ownership at it because I'm not the one that's maintaining it. I'm just the one that typed it. I'm the one that put it in the system so I could get a newsletter, for example. And then it comes down, again, it would just kind of get down to who funded it, who created it. Was it a company? Was it me? Who was it? And that kind of goes into medical mining as one of the minor specific things I wanted to talk about, because it's really, medical mining kind of turns into data mining is what it is. They collect all information about a whole bunch of people. That's like X-rays, blood tests, A1Cs, even like physical therapy stuff. Because the question is they can use that material to kind of see and like guess who's going to have that, what is worse about that disease or something like that. For like A1C, they could say, oh, there's a good group of people that tend to have a lot more a higher tendency for diabetes, or like even onset diabetes and things like that. So there is some good use for it. You could turn around and say, I want to, like, we should put some more effort into saying like better health programs and things like that. But the thing about it is, this is all very gray area because we don't have. There's a very open question. We don't. Who owns it? Like, who owns an X-ray? It's going to be my chest, but do I own that? I can get it if I want to. I can get request that, but I'm not able to go request, a classmate's or a teacher's and things, because there's some really strict regulations about that. But then again, do the physicians own the data? Can someone come up and ask the physician for all of their data, all of their chest wrist X-rays from ages 18 to 25 in male? Can they do that? Does an insurance company do it? Are they able to say, oh, well, I don't technically own it, so I'm not going to pay for it. And this is really just an example of this is the example I really wanted to use because it just shows how messy it can be. And so, for example, this is a broken arm. This is just really someone broke their arm, but who gets to say? We could watch this. We could watch a whole bunch of arm X-rays and figure out where the most weakest point is for potential fracture and things like that, and use that to prevent it in safety measures and stuff like that. But who gets to say? Who gets to go and say this is useful, and on we go? So this is sort of just a general look over who has access to your data. For data, personal identity, that's us. We have a say in that, but that doesn't mean that we're the only ones that can see and have this data on us. We have a lot of issues where, like, we have a lot of things in the government that they can collect this information without much recourse because they have the law on their side, and they can pull things like that. Service providers, AT&T, Verizon, and everything, they have access to everything, because if you're using it through their network, it's implied that it's got to go through a collection center and it's going to be sent. So they're going to have that information, and it really all the way goes down to just about anybody. Anything that you touch on the outside world is someone's going to have a bit of ownership of it. So with that, we're going to go moving into data protection in France. And the French have really forever cared about how their data protections and things like that. This was before even the European Union came around. They were very big about, like, hey, personal privacy, don't go digging where you're not supposed to, that sort of thing. The French Data Protection Act covers personal and sensitive data. If there's a problem, like, they can't just go, like, a law enforcement agency can't just go and dig up your text files without a very, very probable cause. They have to, because all data handlers, they adhere to the same requirements, and they can get into a lot of trouble if they don't. And the French Data Protection Authority, I'm not going to pronounce the French version of it because I don't speak French. They're charged with the application and oversight of French data protection laws, and so they're a big part. And if a law enforcement officer believes that I'm a threat, they have to go convince this authority that I'm a threat, and it's an immediate threat, that they can get my information from it. This sort of kind of rolls into some of the other stuff that we're going to talk about, so I'm just going to keep going. The anonymous hotlines is a very big deal here in the United States. We use them all the time. They're in our code of conduct, and most companies, the company I work at personally, has one of these. But in Europe, there's a lot of negative feelings and connotations because of World War II, World War I, and there's just been a lot of things where people could be reported anonymously with no legal recourse and things like that. Even President Macron in France said he really doesn't like online anonymity. He's been talking a lot about how to reduce the amount of anonymity you have online, because he feels like with that sort of anonymous hotlines and things like that, you could start a whole bunch of stuff and face no problems for it. Here in the United States, like I said, we have to have them. The McDonald's and this French company also tried to set up an anonymous hotline, and the French Data Authority rejected it because it could lead to an organized system of professional denunciation, which in layman's terms is that people could just talk and talk and talk and cause problems. So data protection in the United States is a little bit different. We leaned a little bit more into doing specific laws for specific things. So we have HIPAA for medical purposes. We have, NIST for professional and professional protections. We have the FISMA Act for the security of the government. So we have sort of different things instead of just an overarching problem. So one of the big things was Sarbanes-Oxley was in 2002, after a lot of companies were caught doing some very illegal and very unethical behaviors. And this is where the anonymous hotlines came in really into play. Before this, there had been a lot of companies moving to this, but this sort of made it the national standard. And when inevitably every company tries to move internationally and into Europe specifically, there's a lot of problems with it, because foreign company, that's one thing, but then foreign companies who also are listed in the United States has to also follow this, which causes a lot of fun for European companies that are trying to be in the United States, because they have to have the same type of rules that go directly against their rules in their homeland. So this is going to kind of roll into labor law and the protection of privacy in Germany. I actually spent some time in Germany, so I kind of saw a little bit of this firsthand. I was there for about 6 months, but I was not here when this happened, but I heard a lot about it. So one of the defining cases for the data privacy and the like fight for the United States companies is Walmart. Walmart moved there in the early 2000s, and they tried to implement the same kind of code of conduct and things like that that they do here in the United States. And in Germany, they do not like code of conduct because they feel like it's an infringement on people's rights as citizens. And their local labor court invalidated parts of it, just parts of it, because some of it makes sense, but like covered parts of the global conduct, and it was under fire for quite a while. It took there was an anonymous hotline that Germany said absolutely not. One of the some other things we'll talk about on the next slide, but eventually what led to this was that Walmart deemed that the profit that they could make from working in Germany was not worth it, so they closed all of their stores in the mid 2010s. And one of my things that I found really interesting about this was that they, in the Walmart code of conduct, and in a lot of code of conducts, you'll see a fraternization policy where where employees are not allowed to fraternize romantically with other employees. And as it writes here, the basic law, it was one of the very first founding documents of the German government, said that the dignity of man and the free development of personality are central values. And they felt that saying that you could not, or telling you could not fraternize with specific people was an infringement on that right, because it was prohibiting you to be against your own personality, and it wasn't breaking any laws, and so that was deemed acceptable. And this was a big breaking point for the Walmart's legal team as well. And one of the, I don't think I haven't mentioned, but one of the other things that in this reading we talked about, and I did some more deeper discussion about this, was in a little bit further down in the code of conduct, it talks about how you should always act like you're on the clock. It was I don't remember the exact wording of it, but it was like you should always act like you're representative of Walmart. And the German government was not happy about that because they believe that once you clock out, you are your own person and you can do what you want as long as it doesn't violate Section 1, stating that you did not violate the rights of others or offend the constitutional order or moral law, which you don't most of the time. And they felt that that was a very big infringement. Here in the United States, that's very common. That is a very common thing to read in a code of conduct of like acting like you're always on the clock sort of thing. So with that, we're going to kind of roll into, again, the challenge for the United States companies. We kind of talked about Walmart, we talked about a different couple companies, but I want to talk about the specific challenges that are coming because of this. The privacy in the EU and the code of conducts. Thanks, like I said, there's been, thanks to Sarbanes-Oxley, there's been a push for code of conduct, and these are consistent with our United States rules and protections, but not consistent with Europeans. And this is because the Europeans take a much stronger stance on personal privacy and believing that the workplace is separate, that the work-life balance is once you leave and don't take it with you. And the EU specifically says something about how everyone has the right to privacy and his family life, and that is a core standard in the European governments. And one of the large, like I said, one of the large contenders in code of conduct are the anonymous hotlines. So it's important to note that almost every rule governing Europeans' right to privacy is strong in the United States. This is just an unfortunate fact. I could talk all day about how the United States feels like we're more friendly to company privacy than we are personal privacy. But in the European Union, Germany and France specifically, they believe that everyone has the right to personal protection, and they have specific rules and regulations to stuff like this. Like in France, you cannot, if you're reported for something, you have to be told within a day. You have to be told within a day, and the very limits of the amount of information that's allowed to be gathered about you without your consent is very low. They can get some very basic information, but when it comes to anonymous reporting, they can't do that. You can't just essentially sling mud and get away with it, because you have to have personal accountability, and you also have to consent to that information being released about you. So one of the big things in Europe in 2016 was called the General Data and Protection Regulations. This is a very big, very broad-spanning legal framework that was set out that allows individuals to have control of their own data. And this is what we talk about. They have if there's a data breach, that they have to be informed almost immediately. There has to be the fines in the European Union are very high. Down at the third bullet point, we talk about there's two tiers. It's either $20 million or up to 4% of global revenue, whichever is higher. And for some other companies, for some big companies, some Fortune 500 companies, that's a big deal. And so one of the big things they talk about is when you can possess their data. This is when you when you accept all cookies, for example. In the EU, it's different. You have to be it can't be just an accept all cookies button. You have to have a explicit statement of this is what's going to be used for what, and you have to have all of that information available. And processing is also when you're buying a house or things like that, that information is obviously, you can have that information. When you need to process that information to save somebody's life, there are some very interesting regulations on that. When it's to carry out an official function, so when you're running for a state seat or anything like that in Germany or France, and you have a legitimate interest, this is they say this is the most flexible, but this is also the most where the core principles of the EU come into play. The fundamental rights and freedoms of the data subject is a very big thing, especially when it's a child or somebody who doesn't quite know what they're getting into. As responsible adults, we kind of know what we're getting into when we're getting into the internet. But when you're not, you're just trying to sign up for something and you have to put your child's information on there. And that's not fair to them. And the GDPR protects against that sort of thing. So we're going to talk a little bit about questions, some recommendations real quick. So the U.S. global companies have to consider the best way to fully comply, because they can't comply with one and not the other. And there's no simple solution to being Sarbanes-Oxley compliant and GDPR compliant. It's also worth noting that in the GDPR, you have to demonstrate that you are compliant. You can't just say, "Oh, we're compliant." That's not how that works. And they are very big deals about that. And they have routine inspections and things. There's an entire department focused on making sure people are compliant on this sort of thing. And they had to circumscribe the scope of the whistleblowing hotline. This is usually one of the biggest hangups in code of conduct when you move abroad. And so companies have to accept that. And I think, and as we're getting into this more globalist economy, United States companies are starting to see that a lot more. And the German government, and especially the EU, and especially Germany, want promoting non-anonymous confidential reporting, saying, "Hey, we have to have your information, but like if this turns out to have merit or not, or in good faith is usually the term of, if you report something in good faith believing something is wrong, there will be no retaliation." And that's a very big deal. So that is what they are trying to do. It's also worth noting that the GDPR is also becoming, it was in 2016, which is about to this day, it's about 6 years old. And we're already so far ahead in technology and things like that, that the European Union actually just was celebrating its anniversary and announced that they are looking at a new kind of legal framework that builds off of the GDPR, but that goes further to protect data rights and things like that. Because in the last half decade, we've seen a lot of data privacy breaches that are just absurd about how much information we have out there. And I'm going to leave you with this quote. It's by Peter Sondergaard. It's "Information is the oil of the 21st century, and analytics is the combustion engine." And I thought a lot about this as I was doing all my readings for this presentation. And this is very important. We are in a time and place in our civilization that this is absolutely true. Information is going to guide us into the next millennia, essentially, I feel, because all of this information is becoming available. We're able to reach and research just about anything. And people in that turn are able to turn around and research things about us and learn things about us that we may not necessarily want them to know. So I think it's always important to remember that your information is going to be out there. It's just how much you want out there. For example, during this class, I took some time to look and see what kind of information I could find on like just a random computer with none of my information in it, and see how fast I could find my phone number or a mailing address for myself. And I was shocked to say it took less than a minute. And I think that's just something we have to think about in the coming years as information gets bigger and more people are entering the internet, and what we want done with that information. So thank you all very much. If you have any questions, feel free to reach out to me, and have a wonderful evening.